Case on this morning's docket is case number 112511, a matter of Jarvis. Council, before you start your presentation, I wanted to remind everybody that, as you just witnessed, Justice Biles is recused on this case, and he's being replaced by the Honorable Gunnar Sunby, who is the district judge in the 1st Judicial District sitting in Leavenworth. He is the jurist to my far right, and he has read all the materials for this case. He will be fully participating in the case's resolution in our conference this afternoon. And I wanted at this time to publicly thank Judge Sunby for taking time away from his immense duties in Leavenworth to come help out the Supreme Court today. So thank you, Judge Sunby.
Thank you. It's my honor to serve.
Thank you. Counsel, you may proceed.
Thank you. May it please the court, I'm Alexander M. Balzac, Deputy Disciplinary Administrator. Mr. Chief Justice, with the court's permission, I would like to reserve 3 minutes, please.
3 minutes is granted.
This is the original case of attorney discipline against the respondent, Lawrence Michael Jarvis. The hearing panel was over 2 days. The proceedings were contested. At the conclusion of the proceedings and in the final hearing report, the hearing panel found that the respondent violated seven different rules of professional conduct with multiple violations of 8.4D. The formal complaint consisted of 5 separate complaints. The first 2 complaints were concerned in a diversion agreement. That is the complaint of Judge Russell and the complaint of Greg Bloom. The 3rd, 4th, and 5th were separate, and they're post-diversion complaints. In the diversion agreement, the respondent stipulated that he violated 1.1 competence, 1.3 diligence, 8.4D prejudicial conduct to the administration of justice. In the 3rd complaint, the hearing panel found that he violated the terms of his diversion agreement. That was also true in the 4th complaint. And in the 5th complaint is a complaint by Judge Amy Harth. And the hearing panel found that he violated 1.782, 1.8E, both of those are conflict rules, as well as 8.4C and 8.4D, especially in the light of KRPC 1.14B, which deals with attorneys' obligation towards a client with diminished mental capacity.
Could we back up here real quick? I just procedurally, you received a complaint or a notice at the time the diversion agreement was in place. You received a subsequent complaint regarding some misconduct. Is that right?
There were 3.
And based upon those allegations, the complaints, you revoked diversion sua sponte. How did that work?
No. What had happened was the respondent was on a diversion agreement.
Correct.
3 separate complaints came in at separate times, but they're post-diversion.
Right.
They were docketed. They were sent out for investigation. They were provided to the respondent. He responded. The reports of investigation came in, and then the attorney who handled the complaints did a report to the review committee on all 5 complaints, with the recommendation that the review committee revoke the respondent's diversion agreement.
Okay, so
and send all 5 to a panel hearing.
the diversion was not revoked until Mr. Jarvis had an opportunity to be heard?
On those three, yes.
Okay, Mike, I guess as I read the status of the case, I thought diversion was revoked prior to any kind of hearing panel hearing.
Well, it was.
Well, then tell me how, again, I didn't think that isn't what you just said, Mr. Walzak. Explain, when was diversion revoked? Or when did you do that?
The review committee revoked the respondent's diversion agreement prior to the panel hearing at the same time when they ordered the panel hearing.
Okay, so my question is his diversion was revoked by the review committee prior to Mr. Jarvis having any opportunity to be heard on that. Is that correct?
As to the actions of the review committee, yes.
Yeah, I just want to understand the process here.
Yes.
Okay, thank you.
The process comports with and followed literally Supreme Court Rule 203, which sets us out. And there is no complaint by the respondent that there was any deviation from Supreme Court Rule 203. The exception taken by the respondent is that prior to the action, and as Judge Rosen's identified, was that prior to the decision by the review committee to revoke the diversion, he asserts there should be a separate hearing on that before the review committee acted. Following the panel hearing, or excuse me, at the panel hearing, I recommended that the respondent be disbarred from the practice of law for the misconduct in the case. The hearing panel interpreted the respondent's request that he be permitted to return to the practice of law after he had been cleared by medical professionals. The hearing panel unanimously recommended that the respondent be indefinitely suspended from practice of law. The respondent filed exceptions to the final hearing report, and it is essentially centered on one issue. That issue is whether or not the revocation of the diversion agreement by the review committee somehow was deficient or deprived him of due process. He also raised another issue in his exception as to whether or not the sentence recommended by the hearing panel was excessive. However, in his brief, the respondent does not follow up with any type of argument and recommend that issue be treated. Additionally, what's very noteworthy is that the complaint of Judge Harth, where the hearing panel found 4 rule violations, there was no exceptions taken to those, and so they should be deemed admitted. On the issue of the revocation of the diversion agreement, again, 203 provides, and it was the clear language within the diversion agreement itself, which literally quoted the rule, that if, and the respondent signed, was the understanding that if he violates the terms of the conditions, that matter would be reported to the review committee, and the review committee has the option of revoking the diversion, as was done in this case. Now, my argument is that the respondent's argument that there ought to be some type of pre-hearing or pre-type of ability to be heard on the revocation was done in this case. And it was done in this case because it went to a panel hearing. The Rule 203, and as agreed to in the diversion agreement, says if the review committee determines that there's been a violation of the terms of the condition, it reverts back to traditional formal attorney discipline, which happened in this case. The hearing panel advised the respondent that whether or not he violated terms and conditions of the diversion agreement was before them. There was evidence heard. The disciplinary administrator testified as to the meanings of the term to associate with Kansas counsel if he was to file any future litigation. The respondent had an opportunity to cross-examine, and he did. The respondent had an opportunity to present evidence, and he did through his testimony. When, under the rule, when the review committee revokes diversion, again, it just reverts back to the original proceedings. There's nothing lost. No discipline is imposed. The review committee, the hearing panel can make the findings that the terms and the conditions of diversion were not violated, and make that report. Further, the whole process here is subject to this court's review. There was no decision made by the disciplinary administrator, the review committee, in accordance with the rules, and the respondent acknowledges that the rules were followed in this case. There was an issue within the respondent's raising of the issue of revocation of the diversion agreement. Turned on the word and whether or not he violated paragraph 10A of the agreement, which is provided that he must associate with Kansas counsel in any future cases he would file. There was a disagreement between, the hearing panel heard a disagreement between Mr. Hazlitt, who testified as to his understanding of the meaning of that phrase at the time the agreement was entered into, and his current understanding, as well as the various interpretations given by the respondent. The hearing panel, as you may well note in the final hearing report, made a factual call, like they're required, where they labeled the respondent's argument as specious, finding that it was without merit. What I'm asking this court to do is to affirm the findings, the conclusions of law, and the recommendation for disbarment. Why disbarment? Because of the egregious conduct found in the violations that appear in the Judge Hart's complaint, especially the 8.4D, where the hearing panel labels it as egregious, where he formed a limited liability company after he knew that a court had appointed a temporary guardian conservative for an elderly client who had diminished capacity, and knowing that, the respondent formed this company to do an end run to file lawsuits to collect money and proceeds. The hearing panel also found that the respondent's conduct was knowingly, intentionally done, as well as I'm asking for disbarment based on his prior attorney record and the finding of the hearing panel, the vulnerability of his client who was injured. Are there any questions?
Any questions of counsel? Thank you.
Thank you.
May it please the court. My name is Lawrence Michael Jarvis. I am the respondent. After great reflection, I have decided to accede to the complainant's argument found at page 4, paragraph 2, lines 1 and 2 of his brief, to limit, and I'm quoting, limit the issue on review to the challenging of the revocation of the attorney's diversion agreement. That is how he said that's the issue before you, and I'll be glad to limit it to that, although there's many other issues he doesn't want discussed. His ex parte communication with the hearing panel chairman, Mr. Condeman, many others we're not going to discuss. He wants to limit it to that issue. That's fine with me. Rather, I was denied due process of law by the way Supreme Court Rule 203 D2 VII 7 is presently written, and as it was applied to me, Judge Rosen, which I will answer your question, I think, more directly than the two attempts you made to try to get it from my opponent. How did it work? Here's how it worked. I opened my mail. I got a letter from the disciplinary administrator's office saying, your diversion agreement is out. You breached it. You breached it. You don't have it anymore. Everything you negotiated, all the stipulations you made, you're out. You don't have it protecting you anymore. It's over. It's done. It's over. And I'm going to get to quoting Mr. Hazlitt, but that's how it's over. No due process of law. Regular mail envelope. Your diversion agreement is over. You've got 5 complaints coming up, 2 that were before. Now you have the breach of the diversion agreement itself, self-proclaimed by the disciplinary administrator's office. The 2 prior diversion complaints, the breach we have found you made without any hearing, without any notice, without any opportunity to present evidence, witnesses, cross-examine their witnesses. We proclaim you breached it. It's out. It's over. It's done. And that's an ethical charge against you now too. And all the stipulations, Mr. Jarvis, you made with me to get the diversion agreement are now evidence, irrefutable evidence against you, because you stipulated that you did A, B, C in violation of the rules of evidence, ethics to get this agreement. You can't refute those. They're irrefutable. And because we found at this non-hearing that you didn't know about, that you breached the agreement, now
Let's back up here, Mr. Jarvis. It
Yes.
isn't a part of a diversion agreement, and I'm equating it to criminal diversion agreements, but don't they include a stipulation that you agreed to that the underlying complaints are valid? I agree with the facts of those underlying complaints.
And further, Your Honor.
And wait a second.
Yes. Very
And and further, if you do breach the agreement, or if somehow you have another charge, or however that works, those complaints become a complaint in which you can be disciplined for.
You agree?
That's an inherent diversion agreement, as I understand them.
Yes, sir. You agreed to the facts and that you violated
Right.
the ethics.
Right.
And if you violate the diversion agreement,
And your complaint is that you really didn't have an opportunity to be heard before the conclusion was made that you violated the agreement, at least as
Absolutely.
it
No
as it
notice.
pertains to the review committee.
Absolutely.
And that's your complaint.
I
Not
was
that you didn't stipulate or you didn't have any of that. It's just your complaint is that prior to the review committee making a determination that you violated the terms of the diversion agreement,
Judge
you
Rosen.
just had no opportunity to be heard.
Absolutely.
And
I
so
did stipulate.
that's right. But you did have an opportunity to address your complaints here, and what you're concerned at the hearing panel, didn't you?
Yes. No hearing panel is going to overrule. This is an intra-agency handling. No hearing panel is going to overrule the committee. Yes, I made an argument to them, to the hearing panel, before it started, saying by appearing here, I'm not waiving my due process argument before you. My first defense in my answer to the formal complaint was, I've been denied due process of law. Supreme Court Rule 203 D27, as presently written, is unconstitutional denial of due process of law. It deprives me of a very valuable thing, contractual right, my diversion agreement, which protects me from this very proceeding, the panel proceeding. I plan to retire and agreed to retire in August of this year. And that was negotiated, and it's in the agreement.
And based upon arguments, as I understand it, from opposing counsel, you have suffered no loss because, to follow up on Justice Rosen's question, you got to litigate the question of whether the revocation of the diversion agreement was proper.
That's right. I didn't get to litigate, I didn't get to present any evidence, hear the evidence against me.
At the panel hearing is what I'm talking about.
At the panel hearing,
That was, are you disagreeing with opposing counsel when I understood him to say you got the opportunity to litigate whether that revocation was proper, granted not at the review committee level, but at the full panel hearing? You did not get that opportunity?
No. I mean, it was after the fact. It was already a fait accompli. It was already done. They had already revoked my diversion.
Well, the review committee had, but
Yes.
the people who had an opportunity to relook at that question, it was not the review committee itself, it was a panel of attorneys, correct?
And yes, and they wouldn't do it. They said they wouldn't do it.
Well, my understanding of what you've said so far is that the heart of your complaint is that once the review committee made its revocation, then the game was over because this panel of attorneys would never overrule the review committee's determination. Did I get that correct so far?
You are correct. And they would never do it. I don't even know if they have the authority to do it. And they wouldn't do it. The Supreme Court rule says, 203 D27 says that the panel can do it. I don't believe, the committee can do it. And they did it. I don't believe the hearing panel is going to say, we can overrule the the panel, and we can overrule the Supreme Court Rule 203.
Was the context of the contested issue in front of the hearing panel?
The five complaints.
Right, but I want to focus in on the contested issue, as I understand it, was whether or not you violated the rules of conduct when you violated the diversion agreement. Am I correct in that understanding?
I think one of the big disagreements, Your Honor, was whether Stan Hazlitt and I came to an agreement on what associate with counsel meant. Mr. Hazlitt had in his mind, and he testified to this, that any case I had, not just ones I filed, I go to police court, I have to have another attorney standing with me.
I'm afraid, and I understand that, and I'm probably not asking the question very clearly. But what I'm driving at is, from your perspective, your understanding of what was going on at the hearing panel. Was it essentially an appellate review process of the review committee's decision, or was it a new process to decide whether or not that was an additional ethics violation?
It was whether I had violated the 5 complaints and the diversion agreement, which had now been breached, and an additional charge made against me in the self-proclaimed breach.
And it was that additional charge for which the hearing panel was receiving evidence. Is that right?
Yes, they heard the testimony of Mr. Hazlitt against me. And as I will get to, Mr. Walzak indicated to you, I'm going to jump to the end of my presentation so I can answer him. He said to you that I had no harm, he suggested to you. I had no harm because I could go to the panel. Well, I'm suggesting to you the panel is not going to overrule your Rule 203, which says that Mr. Hazlitt can do to me exactly what he did. I don't say that Mr. Hazlitt couldn't do what he did. I'm saying that Rule 203 denies me due process of law. Read it. It says, without a hearing, without notice, without opportunity to hear the witnesses, present any witnesses, present evidence, I can get an unregistered letter that says, you don't have your agreement, your property rights that you negotiated for. You don't have the shield of the diversion agreement anymore. It's gone. In fact, I asked on cross-examination this paraphrased question of Mr. Hazlitt to get his understanding of what due process means for the termination of a diversion agreement. Quote, am I correct? The procedure for revocation of a diversion agreement can be, after the fact, respondent gets a letter, it's done, the agreement is breached, we say so. You're out. Quote, not only you're out, you don't have the agreement to defend you anymore, and you can have the additional ethical charge of the breach. Mr. Hazlitt says, correct. My brief, page 30, last paragraph. That will lead you back to the exact reference in the record where that testimony is found. That's what Rule 203 says can happen, and that is what actually happened to me and any other Kansas member of the bar under the way 203 is presently written. I claim to
Was
Your Honor,
was that rule there, sir, when you voluntarily entered the diversion agreement?
the rule was there, yes. Did I have any idea that it could be applied this way? That one part of the agency could say, the committee, have a secret hearing, no notice? No, I had no idea that it could be interpreted that way, but yes, it reads, I mean, if you read it that way,
Who's on the review committee that
Who knows?
revoked your diversion?
I had no idea.
Okay?
The letter
And
comes from the disciplinary administrator's office.
you don't know who the members of the review committee were,
No,
but you do know who the members of the hearing panel were.
I do.
Okay? And those are all attorneys licensed to practice in Kansas, is that right?
Yes,
And,
yes.
and just so I'm clear, it's your position that they were incapable of overruling the review committee? That's what I'm trying to focus on, why you feel
No,
that
I
they
don't-
did not.
I think they could have said, as I ask you all to say, clearly, Rule 203, as presently written, needs revision. It denies due process of law to every member of the Kansas bar. It doesn't allow them to have a due process hearing before a very valuable right, the diversion agreement, is taken from them, turned on them because the stipulations they make in it convict them of the very charge of violation of it. And then, to add to that, another Supreme Court rule, 2014 Kansas Supreme Court Rule Annotated 312 says that is an additional factor to enhance the punishment, the discipline, and it's an additional aggravating factor. If I'll slow down and get the exact terminology, it's another an additional aggravating factor. So here are 3 reasons that I suffered harm. Although it's suggested to you today and in his brief, it is argued by the disciplinary administrator that I suffered no harm because of this ex parte revocation of my diversion agreement. I suffered these 3 harms. All stipulations I made are now, well, first, I lost the diversion agreement itself, which protected me through August. August hasn't come yet. I shouldn't even be before you. I shouldn't have been before the hearing panel. I negotiated through August, which I wouldn't be practicing anymore. That's gone, that protection I lost. Secondly, the disciplinary administrator's self-proclaimed breach at this hearing is now used as irrefutable proof, my own words, I stipulated to it, that I violated the complaint that was pending against me. I don't want to use my valuable time. He said there were 2 complaints pending, and there were 2 before the diversion agreement. Judge Russell and an attorney, Greg Bloom. Greg Bloom's is just a duplication of Judge Russell's. Mr. Bloom and I have unfortunately not been invited to each other's homes for supper. Judge Russell has a valid complaint against me. I was sick, had a stroke, double blood clots through my lungs, and almost died. But the point is, I stipulated to the complaint of Judge Russell in my agreement. It's in writing, you can read it. I did not stipulate to Mr. Bloom's complaint. It's duplicative. And in fact, in my answer, I said, pick one disciplinary administrator. Pick Judge Russell's or Judge Bloom. I shouldn't have 2 about the same thing. Judge Russell's right. I missed hearings. She is right. I was tardy. It worked out. My client didn't lose. He won. In my absence, the other side took a judgment that worked in our favor. And if you'll give me time, I'll explain that. But
Counsel, you're out of time, but I'll allow you to tell us what that 3rd harm was. If you have that in your notes.
the 3rd harm, yes. The 3rd harm is, I'm very sorry, I got the wrong sheet in front of me. The 3rd harm is that the breach itself can be used as an aggravating factor. That's found in your Rule 2014, Kansas Court Rule, annotated 312 on to page 313. So I can have an additional charge. I can now have my own stipulations used against me, and I can then have an additional factor, aggravating factor against me. So the person who, like myself, is a revoked respondent does indeed stand in a much worse position than any other person facing a hearing panel.
Counsel, all of your argument is really focused on this battle over the procedure on the diversion. I'd like to return to the very first thing you said today and make sure that I understand where we are on the war.
Yes.
The overall picture.
Yes.
Does that mean that you are willing to accept their recommendation to us of disbarment?
Of course not. I mean, no. I'm very sorry. I should ask you a question. No, ma'am.
That recommendation is largely based on a complaint that you have not addressed, that of Judge Hart. And is there
I have
any
in my brief.
Any reason, just relying on your brief to mitigate that?
I am. Judge Hart testified. She's a probate judge in Paola and has been for many years. She granted an order appointing a temporary guardian and conservator, an order. She never required a bond. There's no waiver of the bond. She never required an oath. By statute, every fiduciary must have an oath. She never issued letters of administration. She signed an order, ex parte order.
Are we supposed to accept that an attorney can disagree with the procedures or the rulings of a judge and just set them aside by that attorney's own determination that the judge had procedural failures
No,
and ignore it?
no, I think
Is there
you-
any excuse for you ignoring the judge's order of appointment of guardian?
Yes, there's ethics that require me to protect my client if he or she is inhabilitated, and he was. What I did then was to try to file lawsuits for him to protect his property. She had let loose on the community a man with a piece of paper saying, I order that you be his temporary guardian. He then went out in 3 counties and started taking all the money of Mr. Slatter from tenants of his buildings in those 3 counties. I tried to collect that money from Mr. Slatter when they wouldn't. They took the money, gave Mr. Slatter no money, not a dime. His phone was taken out. I couldn't call him. I had to drive 25 miles to see him. I'm trying to protect his assets. When they took the money, the tenants were his ex-wife, divorced wife of 15 years, and his oldest son. He has 3 children. His oldest son, Charles Slatter, this is all in my brief, combined to break him. And they did it. They went to Paola, signed a petition to get a temporary conservator. They didn't allege, as the statute requires, that there's an emergency, that he's going to harm himself or the estate. They didn't allege that in the petition. They got a temporary order signed, no hearing. They appointed a former attorney of their attorney's law office as this temporary conservator. He then went out and, under this order, no bond, no oath, no letters. How can you be a temporary conservator or a fiduciary of any nature without letters? I then went back to the court and I said, these are improper, terminate it. One of his other children said, I'll serve as voluntary. I asked the judge to appoint this daughter, who was asked to join with the mother and son. She says, I won't do it. The daughter says, I'll serve as voluntary. Judge says, no. I said, well, cancel that order. By statute, it only operates for 39 days. This is after the 39 days. She won't cancel it. I said, well, they don't have letters. He's out there taking the money. He's not giving any money to Ralph. He even tried to go after Social Security. If he got that, the man would have starved.
Counsel, I'm going to interrupt and ask Justice Luker, are you satisfied with his response?
Yes, I think he answered my question in the first couple of sentences.
All right. Let me...
I had conflicting rules, and I was trying to obey both of them.
You've told us, as I understand it, that you disagree with the recommendation that you be disbarred. So my question is, what level of discipline would you ask us to impose instead of disbarment?
A time period. As I argued to the panel, that a time period would allow me more time to recover and get medical clearance that these problems I am over. They were, by the way, Your Honor, 8 to 9 years old at the time of the hearing. I had gone to a psychologist of the picking of Mr. Hazlitt and paid for that in Topeka and got a report from him that passed, and before we entered into the diversion agreement. So I think my medical records will approve me to practice. That was at the request of Mr. Hazlitt. Specifically to answer your question, temporary suspension of some length that you say, But at my age, 71, and an indefinite suspension, I believe it's 5 years, before I could even petition to get back in, and et cetera. I believe a suspension of several months, and whatever your judgment would be, but please look at what I was doing to protect my client under the ethical provisions, and what's your judgment I would stay with. But the big question that you need, please, not just for me, for every member of the bar and for yourself, please look at Rule 203. It needs attention.
Then I do have just a quick question.
Yes, sir.
I hear a lot of prisoner cases, and in those prisoner cases, there's lots of claims of violation of due process rights.
Yes, sir.
And you have to look to what the impact was. If the impact is to, say, segregate or to place them in a different classification, they don't have a liberty interest or a property interest in that. And therefore, no matter how flawed the process was, they don't have a property interest or a liberty interest in the actions of the hearing officer. So therefore, even if I find the process was flawed, they get no relief. They simply get no relief because there's not a due process right there. Here, the current concern I have is that you're alleging your due process rights are violated, but I don't see that there's an entitlement to a diversion or a property interest in a diversion. There is an entitlement to, say, welfare benefits if you're poor, the entitlement to a law license if you pass the bar, but to a diversion, I don't see that there's a property interest and obviously not liberty interest, but a property interest that then triggers a review of the process, as you claim. How do you handle that argument?
My property interest is my diversion agreement, negotiated by me with the disciplinary administrator. Stipulations I gave, time I was supposed to have that I didn't get. That was a property right. At the hearing panel.
There are no dollars or cents there, are there?
Well, there's lots. I support my family by that.
No, that's if later action takes you from the practice of law. That's later on. But in the diversion agreement, there's no dollars that you have to pay. There's no fee that it costs you or anything like that. Would you agree? Or
Just my livelihood and 52 years of practice. I believe that's a valuable contract that I negotiated, the right to practice law.
Thank you, Mr. Jarvis.
Thank you, counsel. We
Thank you.
understand your position. You reserve 3 minutes for rebuttal?
Yes.
Mr. Walzak, the revocation of diversion is not an additional charge. It's considered an aggravating factor, or is it an additional charge?
It is not considered an additional charge.
It's just considered an aggravating factor in determining discipline?
If there is a determination that the diversion agreement is violated, yes.
Okay, it's considered
By
yes.
the hearing panel.
Wait a minute.
So
Yes, what? Is it a new charge or is it an aggravating factor? Does it result in
It becomes an aggravating factor.
Okay, so it doesn't result in an additional complaint.
No.
Okay, thank you.
And if I could follow up on that, you litigate. My understanding is that this question of whether or not the diversion agreement was violated was in fact litigated in front of the hearing panel, right?
You're correct.
And it was litigated to determine whether or not it would be an aggravating factor. Is that right?
Correct.
So had the hearing panel determined that the diversion agreement was not violated and therefore it was not an aggravating factor, what would have happened to the diversion agreement?
Diversion agreement would just
It was still.
it still be in effect.
Well, it would be. It would revive at that
Well, I mean,
point.
the diversion agreement, after the hearing panel makes the determination that it was not violated, obviously they do a final hearing report, and that has to go. There's no procedure spelled out in 203, but it would go back to the review.
Well, that's what I'm kind of trying to figure out. If that were to have happened, Because Mr. Jarvis is alleging harm. And in your earlier statements, you said there's no harm because you get to go back in front. You just restart the process in front of the hearing panel.
Correct.
What I'm trying to figure out is, had the hearing panel found that the diversion agreement wasn't violated, I mean, it's still been revoked. Does that finding just sort of automatically resurrect the entire diversion agreement? And the reason that's important is because of the stipulations, right?
Well, yes.
So does it resurrect the diversion agreement or not?
I don't know. We never had that case.
Okay. So then I guess the follow-up question is to ask you to respond to Mr. Jarvis's point, which is, I really am harmed pretty significantly because of those stipulations. I'm not like just put back to square one. I'm put to, I'm put in the hole essentially, because now these stipulations can be used to essentially prove the violations.
The harm, when the diversion agreement is entered into, that is spelled out, the stipulations, and it's also spelled out that it's going to be used in any type of subsequent proceeding.
If the agreement's violated.
Yes. Yes.
Last question that I have. When one of these matters comes in front of the review committee, does the review committee have discretion to decide whether or not to revoke the agreement, or are they just sitting as a fact finder, and if they find it was violated, it's per se revoked? Or do they have discretion to consider equitable matters?
Yes, the rule provides that they could either
They could
reject the recommendation. They can extend or continue the diversion.
Hypothetically speaking, they could say, yes, we find that as a technical matter, the diversion agreement was violated. However, we have equitable considerations, so we're going to either modify the agreement or extend it in some way. They have the discretion to do that, right?
They do, and they have done it.
Okay, but
they have done it in the past. I apologize for interrupting.
No, that's all right. I appreciate understanding that that's what they have done. That's what my understanding was. But when you come to the hearing panel, it seems to me the hearing panel's role is very different. The hearing panel's just deciding, as a matter of fact, whether or not the diversion agreement was violated. Isn't that right?
As on the evidentiary standard, clear and convincing evidence.
They're not deciding whether or not equitable factors might play into a discretionary extension or reinstatement of the agreement.
Correct, but they also consider the stipulations of fact and rule violations.
But what I'm getting at is Mr. Jarvis wouldn't have an opportunity to present any equitable argument he might have for a reinstatement or extension in front of the hearing panel, because that's not what they were there to decide.
He presented that argument. Whether or not the hearing panel, it would be mere speculation.
Thank you.
Okay.
Let me just make sure I understand something. The two charges that underlay the diversion agreement originally were put before the hearing panel, and they decided that he, in fact, engaged in those violations, correct?
Those were their findings of fact based on the
Right.
stipulations.
But part of the evidence to support those findings was were his stipulations in the diversion agreement.
Correct.
Those two charges aside, the hearing panel still found he had 3 new violations.
They found that he violated the terms and the conditions.
No, I'm not talking about the diversion agreement. I want to put that aside.
Yes.
The hearing panel also had before it new allegations of violations that had nothing to do with the diversion agreement.
Correct.
Those violations had not been the basis necessarily of revoking the diversion agreement, or had they been?
That was part of the 3 additional complaints with the review committee.
Okay.
at the time they revoked the
So
diversion.
the only thing that those 3 new violations had to do with the 2 previous violations in the diversion agreement that arose out of them was that they were evidence of the violation of the diversion agreement itself.
That as well as additional misconduct.
I'm trying to just get the relationship. I want to make a division between what supported the diversion and what came later.
Okay,
There were 3 complaints that came later,
correct.
and those included the complaint from Judge Harth.
Correct.
Okay.
Any further questions?
Yes, with respect to the diversion agreement, a condition precedent for the disciplinary administrator's office offering that diversion is an admission to the complaints. In other words, the stipulations that, yes, I did these things and these are violations, that is a requirement before you allow someone to enter a diversion. Is that correct?
Yes.
So the quid pro quo for the stipulation is to be able to have a diversion rather than have the complaint proceed through further prosecution of those complaints. Correct?
You're on right. I would say a little bit differently as opposed to a quid pro quo. A candidate for diversion asked to be considered, or we identify an appropriate candidate, and we ask the review committee for consideration, and the respondent either approaches us or we approach them, and we explain that part of the diversion agreement is that you must stipulate to the statement of facts and certain rule violations, and there's that
That
agreement.
stipulation then is in place whether there's a violation or not.
Correct.
For all purposes from the time forward after the respondent signs that diversion agreement, that stipulation is going to follow that respondent. Whether they successfully complete or not, they've admitted to violating the.
You're correct. It's
rules.
similar to the criminal diversion.
But there is a duration to it, isn't there? How long was this diversion?
Well, what happens is that in this particular case, this diversion was entered into in May of 2011 with the effective date of June. So it was from June 2011 to August of 2015.
So
and what would happen?
about a 2-year period of diversion that he had to kind of remain complaint-free, something
Correct.
like that. Okay.
And if I may
And
follow
then
up.
after that, those complaints just essentially go away if he completes diversion?
If they go away, they don't go away. It's the record of misconduct is confidential. We do not reveal it to anyone. It's only when there's subsequent misconduct, and say a given respondent completes diversion, they get in a subsequent misconduct, there's a panel hearing, and if there is findings of violations, then the diversion agreement, even if successfully completed, can be introduced by court rules.
As evidence of prior misconduct?
That is correct.
Okay.
Any more questions?
If I don't know if it is more personal, it's bothersome, but it's the comment that there was some type of ex parte communication. That is not true.
That's not an issue before
Okay.
us today.
Okay.
According to his stipulation, he was only going to talk about
Okay.
the one
Thank you.
issue, so that's
Thank
fine.
you.
Thank you both for your arguments this morning. Court will take this matter under advisement. That